All right. Well, with that, I know some of us here want to open up with a question. Do you want to just hit the AI right now and just
drop right into AI.
Well, as a programming note, I think kind of what we were thinking is there's a couple of topics that we want to talk about where it's just things that we're like, we want to get up on the soapbox and talk about that we think are important. And then
you
afterwards,
can't stop us.
Yeah, because we got the mics.
But I'm curious, just anyone with just shout out like a pressing legal topic that is hot on your mind. AI art.
Oh,
Okay, well, great. That's
Good.
perfect. Thank you, Plant. But yeah, let's talk about AI art a little bit. So, show of hands, because I think this is a very polarizing issue. Oh, wait, we didn't do the disclaimer. So this is not legal advice. We're not speaking on behalf of any client. This is just our own personal opinions about the law, and talk to us in private if you want some actual legal advice. Then we can, make you a client. So AI art is very polarizing, and I feel like there are probably two major camps. And so I'm curious, show of hands, so who here thinks, and there is no middle ground, that AI art is super duper cool and is going to revolutionize creative production? Cool, you cannot vote twice. Who thinks that it is art theft and a scourge on creative industry?
I voted twice. Is that right?
Spicy.
You're straight to jail. Sweet. Awesome. Well, good. This will already be spicy. So, again, we are lawyers. We're not, economists or sociologists. There are a lot of sort of issues to unpack, and I realize that, we're talking about a lot of people's livelihoods here. So, first want to set the stage and table set that, like, we are very empathetic to people who are directly affected by AI art and, are losing money or jobs because of it. So we will try and be very respectful. And, we also know a lot of people who are actively working on this technology. So we will try not to fall into one camp, one or the other, and sort of talk about strictly the legal issues. I'll stop now.
This is a panel with nuance. I'm sorry. We do exist. So I think, to piggyback off of what Joe said, so I'm a copyright lawyer, so I get these versions of these questions a lot. A couple of years ago, it was AI in music was the big flare-up. And most of my stuff I work on is related to music licensing, so just with that as foregrounding. A couple of things that you need to kind of know just as like a very high-level copyright 101 is that copyright specifically, which is and I bring this because this is usually the law that gets invoked the most when we're talking about AI and AI-generated art. Copyright protects or reserves to the copyright holder the ability to control certain kinds of uses of the work. They can control the reproduction, the distribution, the public performance, the public display. There's sort of a jumble, certain kinds of works get certain kinds of rights and yada yada. Notably, one of the things that copyright does not protect copyright does not reserve to the rights holder, is the ability to control when someone looks at your stuff. So if I go to a library and I take a book off the shelf, or if I go to a Barnes & Noble and I take a book off the shelf and I haven't paid it, I can read it. There's nothing legally you can do to stop me from reading a book. Nothing you can stop me legally from looking at a piece of artwork, so long as I haven't broken into the Louvre to go do it. And so and there's a lot of debate around this. Okay, so this is this is me grossly simplifying it. There's a lot of debate about machine learning and it's the input process. Like, how does it digest existing work? We run into this in text all the time. The Authors Guild specifically has a very, very stringent position about this, saying, well, if it's looked at the book that my client wrote, then it owes my client money, even though it's a robot. And not a human being, and even though a human being wouldn't have to owe my client money for reading the same book. So it's this very complicated topic. I will, however, say the one thing we can all agree on, AIs don't get to own a copyright.
Yeah.
And for once, the Copyright Office agrees with me on something. Copyright has to be owned either by a corporation or by a human being. The monkey did not own its own selfie, for those of you who remember this case. It has to inhere in a human being. It cannot inhere in animals, it cannot inhere in machines, and it cannot inhere in ghosts. The Copyright Office has had to answer that question.
Is that circular 666? Or?
Yeah, exactly.
So I think, one a little spoiler and also plug. So I know there are some extra credits people in the audience. So we will at some point be doing a episode on AI art and talking about specifically the legal issues. And I think one of the sort of good ways to think about it is to think about it in 3 steps. So when you create a piece of AI art, step 1 is you give a work to the machine, or you give a prompt to the machine. Make me Iron Man. Step 2 is the machine looks at a whole bunch of, it uses its algorithm to create a thing that looks like the thing that you prompted it to make. And then the third step is you do something with that thing. And from a legal perspective, there's potential for copyright infringement at all 3 stages. If you prompt the machine to say, hey, make me Mickey Mouse, well, it almost doesn't matter what comes out. You're probably going to be infringing on Mickey Mouse. You're basically directing this machine to make what is called a derivative work of Mickey Mouse, and even more so if you actually give it an image of Mickey Mouse to then build from. And then obviously the third step, we'll skip the second step for a second, is to, if I pass off this work that I just created as my own original creation, if I don't, if I say, oh, this is actually like an original, who's a famous artist?
Gustav Klimt.
Yeah, this is original Gustav Klimt.
We're not artists.
Or I, try and pass it off. Obviously, that's going to be problematic too, and that's actually not so much copyright as a trademark issue, as falsely attributing the source of the goods or services. Now, I'll stop there because I think the second step of the process is AI art inherently problematic because it's looking at and storing these images in memory for the purposes of training its algorithm. That's where I see there's a lot of really healthy debate.
Yeah.
Now, on the one hand, this isn't completely a new issue. Artists, so they're talking about art in this case, will go out and look at things to get references and get ideas. If I want to draw a unicorn, well, I might look at horses, but I might go and see other people who have done fancy art. I'm going to look at your unicorn, I'm going to look at your unicorn and your unicorn, and then I'm going to take those in my own mind, and I'm going to draw my own unicorn. The issue for copyright infringement is it substantially similar, basically. Now, there are variations in nuance, but basically, is it substantially similar enough? Does it look enough like your unicorn that clearly I copied, and that's a problem? And then we get into all sorts of, for that, filtering out, okay, well, there's a horse. I look at that horse. We can both look at the same horse and draw it, but we're looking at the horse, and there's no copyright in that horse over there. It's a real-life thing. No one owns that. So on some level, it's not an entirely new problem. We've dealt with people being inspired by, or inspired, wink, by other things and other people's works and whatnot, forever, since way before there's been a copyright statute in the books in the first place. So that's not a new thing. Part of what I think, in my mind, 2 of the issues, and feel free to chime in a minute. One, we're able to do this on a much grander scale. You can say, all right, go find every unicorn in Google Images, go get them, and then it happens, in a moment. And then it's filtering through all that. And the second is a computer issue, which isn't quite a new problem. We've had computers for decades now, but you're making copies of all that, feeding it into the AI program that it then processes, even if it's just temporary copies, and then spits out the end product. And that's where a lot of the problem is probably going to be happening.
So I swear I'm not going to harp on this forever. Because we only have an hour. But there's sort of 3 things. Two of them are simple. One of them is the big policy question. To piggyback on Sam, first, you can't copyright a style. Okay, your style of art, Andy Warhol's style of art. Well, actually, if there was art majors, let's not fight about Andy Warhol. But Gustav Klimt's style, John William Waterhouse's style, public domain, you can't copyright a style of something. So if you make yourself a Disney Sona, you're not infringing anything because you're doing something deliberately in the style of another author. You've never been able to copyright that. Two, we have been on a trajectory, and this question of how much is a computer and how much is a human creativity is an existential question that we've been wrestling with for quite a while, all the way back to the beginning of software copyright. The very first lens flare filter on Photoshop, there's I think a non-frivolous argument, and I say this as an artist, like a hobbyist artist myself, that a lot of what we do is automated now and buttressed by computers, and so there is a line drawing problem. Like, is it enough human creativity simply to say, give me a picture of Bruno squatting behind the potted plants or whatever, and to an AI versus if I just filter the hell out of something. So that's the second question. The third is the big policy question, and this is something that we run into in all machine learning and AI training debates, be it in here, be it in the sciences, be it in data mining, take your pick. AI is fundamentally an algorithm, and fundamentally, garbage in, garbage out. Okay, this is a core principle of AI training. You can only get results as good as the inputs that you put into it. If you remove from the possible training pool all works that are protected by copyright, what you are left with is works that are either in the public domain, which I'll talk about in a second, or works that are in the public domain by virtue of being old. So you get printed materials that were published before 1927. I will give you one guess as to the general demographic that those writings represent.
Yeah.
Writings, paintings, and photographs. This came up a lot in facial recognition technology. I don't know if you remember about 5 or 7 years ago, there was a big blow up around facial recognition technology, which doesn't work on people of color. And for a very long time, they ran it on members of Congress, and it misidentified something like 75% of the members of Congress who were people of color, and erroneously identified them as having mugshots. It was absolutely wild because one of the sources of public domain facial photos is mugshots, okay? And you can guess what groups are over-indexed on those. So whenever you have a system which, and I'm advocating for this as a policy matter. I think this is separate from the legal question of copyright infringement. But the policy argument for it is, if we are going to have these things, and I personally am of the opinion that the genie's out of the bottle. You're not going to get that one back in. It is better to train them on as wide a possible set of data and as representative of the actual real world and the real population set of data as does exist. And copyright can put huge monkey wrenches in that and really lead to some skewed results.
And I'll throw out one other on the same policy note, again, taking the lawyer hat off and putting the policy hat on, is, if I see a lot of people saying, oh, well, we should set up a licensing regime. So, if these copyrighted works, I'm going to license my work as an artist to be included in an AI algorithm data set. It is a good idea in theory. The problem is how many people here know what Spotify is. Exactly. So, and how many has ever made any money off Spotify ever? So the problem is if you put a price tag on AI art, well, the algorithms they're not going to pay you very much. They're going to pay you a nickel for everything you've ever done and will ever do. And, that'll actually be a pretty good deal for you because they're not actually recreating your art, they're just using it to train, right? And if you don't take that art, then they'll hire somebody to just crank out art day in, day out. So I have a bit of a concern with saying that, a licensing regime is the magical solution to dealing with AI art. Because, again, you're also going to have the problem of the data set being only the people who have opted in, and that's going to make the actual output worse.
Yeah, well, I mean, just to bring it back to the lawyer principles here, I mean, there's so many interesting policy questions on the front, what can it use, what can come in, but I mean, I think it's important to focus on that middle step that we were talking about. What is it doing in the creativity process? So as Meredith said, I mean, anybody can read anything. Everything that's ever been created is based on something that came before. Looking at, say, video games as an example, copyright is not meant to protect these ideas, the sort of themes, the styles, that sort of thing, because that's the language that we use to communicate and to make art and that sort of thing. So you're allowed to make something that is inspired. I think the sort of key issue from a copyright perspective for a lawyer is in that middle step where the AI has ingested stuff and is generating. Is what it's doing, being inspired by tropes and themes and ways that things are done, or is it just simply copying this piece and this piece and this piece without really putting its own spin on it? And I think when you look back at copyright is not your content and your scene, it's the expressive part of it. Can machines be expressive? I think that comes back to kind of a foundational question that just governs, is there creativity, is there expression in machine output? Because I think a lot of what we're talking about is it infringement? But then there's also the question of, is it creative, is it expressive? And I know you pointed out that machines can't own copyrights, but this is something that's bled over into my domain, into patents, because we've been seeing, there's been at least 2 patent applications where a machine allegedly came up with a brand new invention. And so they filed a patent application saying nobody's ever done this before. And it's a big question. Is it inventive if a machine could kind of put it together? So I think that's where you see sort of the spillover between all the IPs.
I mean, we always joke that, copyright ends up being the canary in the coal mine for all kinds of tech stuff. But if it's the canary in the coal mine for do machines have a soul, I'm going to be so pissed.
Oh, I'm going to be so psyched. Oh, are you kidding?
There are 2 kinds of copyright lawyers.
I mean, like 40 years from now when we're on a panel talking about like post-singularity copyright law.
It'll still just be the 4 of us.
It's going to be great.
Everyone's left.
No, I mean, I think that it is kind of goes to, I mean, the good news that I tell most artists is, from a strictly legal perspective, as Meredith and we've already discussed, a machine can't own a copyright. So there's a really good reason to continue to pay artists, because if you are putting art in your game, you need to make sure that you own it, both because it has value, and also because someone else, you have to protect yourself from someone else stealing it, and. So yeah, if for nothing else, you should continue to pay your artists so that they can take the art that was created by the AI, repurpose it for themselves, do it themselves, then they own the copyright, they can assign it to you or license it to you, however you have that set up, and then you own it, and then you're protected from subsequent infringers, including other AIs.
It looks like you in the, third row had a question. Go ahead.
I was going to ask it, I don't want to derail that. But the other side of the ownership question for digital things, in terms of these days buying like a book on Amazon and then suddenly having that book removed from your Amazon account or your Kindle. So kind of like, or buying something on Steam and then having that. So what is ownership, what does the property right look like in the digital age?
That's great. I love it.
Yeah,
so
that's
just,
like our. You just
like
asked
on the
my
bingo
job
card.
description.
Yeah. So real quick, for those who couldn't hear, basically, what does ownership look like in the digital age of all these digital assets, like books and games and stuff on Kindle and Steam and whatnot?
The short version is it doesn't. It doesn't look. It doesn't.
Yeah.
Period. It doesn't be. Sometimes you think it'd be like that, but it don't. The short version is that we have moved to a licensing culture. So there are some weird side effects of how courts and the legal system have basically treated software historically. And without getting into the details, the very, very, very short version, and you can use this to impress friends at cocktail parties, is that copyright law requires a physical object. And this never really jived well with software. And so the way that we have talked ourselves into this is courts said, well, we're going to have this legal fiction that the physical object is that 1 micrometer of disk space on the disk. And that physical object is enough to qualify for copyright protection. Now, what this means is that every time you defrag your hard drive and you're moving stuff around on the physical disk, you're violating copyright law because you're creating new physical copies. And you're not allowed to do that. And you laugh, but this was literally the crux of a decision sharing that, ShareTunes? It was like an iTunes locker service. And this happened recently, where the idea was I will upload it to a locker and then someone will pay me money and I will delete it off my hard drive and the new person will have it, ergo I have resold my MP3s, and the court was like, no, you haven't, even if you've deleted your own, you've technically made a copy and you're not supposed to do that, so this isn't legal. So the short version is that we've built up this licensing culture, which is like, oh, you don't actually own that file. You have permission. You have a contract, basically, with the person who created the file. And so when you use a service, everything is Netflix. Just keep this in mind. Every time you buy something digitally, it is Netflix, meaning it can disappear out of your catalog at any given time.
Well, hold on. So I want to push back on it a little bit. So, yeah. So this is actually for me personally as a lawyer. I thought I was going to be an IP lawyer, and I more and more I am transitioning over to doing more consumer protection work, because good news about the law is there are lots of different ways of looking at a thing. And so, yeah, even if you don't own this thing that you licensed, well, there are actually some consumer protection laws that have been passed that prevent, companies from just taking your shit away without notice. And more laws like that continue to get passed, including in the EU in particular. So there's this Digital Services Act. I won't go into the details.
Yeah, Joe and I will fight here all hour. If we
Yeah,
get
well,
into
the point is that there are other tools available if a company dicks you over, and that is where actually a lot of my work kind of sits. Is when companies remove things, when they do it accidentally or on purpose, and players get angry, there are other legal recourses other than using property principles. Basically, under the FTC, there's literally just, you did something that was unfair or deceptive. That is the legal standard, and wow, is there a lot you can, talk about what is unfair. And so, there are other regimes that can pick up the slack when property principles don't apply.
Also, contracts is another one.
Contracts.
Again, no one ever reads the EULA, the terms of service, but a lot of stuff is in there, and it will go over. And typically, it's just broad. We can do anything we want. Is the gist of a lot of them. Fair enough, but there are things in there, and if the company is violating the terms of service, which is treated as an actual contract between you, the user, and the company offering the services, that's bad. They violated the contract. That's a lawsuit potentially. And, are you going to be able to sue over it practically? I don't know. Probably not. You probably can't afford it. But that is one other recourse.
So class action lawyers do. And
They do, but also a lot of these EULAs, if you actually get into the guts of them, are basically the Cartman "I do what I want" meme from whatever company's issuing it. So
Yeah.
So question from Apollo Justice.
Yeah, got to take that one.
nice.
Need to take that one.
So weird sort of portion, I don't know if you guys are familiar with like Destiny 2 at all. What they do is in the game is they have to, because there's so many assets and the game is so big when they add new stuff, they have to do old stuff. What would happen if Bungie decided to resell them in terms of work, decided to resell that content that they had taken out? How would that interfere with, ownership, copyright, or not copyright, with ownership if a player's already paid for that? So, because like, if they use the exact same assets, I'm just using Destiny as a blanket term.
Sure.
Right.
Sure.
If they were to resell you a game with the exact same assets and something you've already bought before, but it's under a new name,
Oh, you mean like EA Sports?
Oh, so like, ouch.
So,
Sorry,
for
burn on my
example,
old former
Destiny.
employer.
Yeah. Example, in Destiny 2, sometimes the game, they have too many assets. They have to take some things out to add new content in. Let's say you bought the old stuff that's removed. What if they then brought that back in and made you pay for it again, possibly under a new name or slightly different shading variation?
So I think there's you got the two angles. There's the property copyright angle, like terms of service angle, in which case I think it's actually pretty clear cut that if it's a competently written terms of service, you're out of luck. You don't own the content. There's usually very, very clear language in a terms of service saying that virtual entitlements are not property. That is important both for, CYA purposes if we lose it, but also because there's actually like securities laws and banking regulations that kick in if you start actually ascribing real property value to virtual things.
Destiny 2 is a bank.
Yeah, exactly.
We can get into that a little bit later, but yeah.
I think from a consumer protection side, you might have a better argument if you said, oh, I wouldn't have bought this thing had I known that they were going to immediately get rid of it and then resell it. And so, from a consumer protection standpoint, you might go use the California unfair business practices laws and fight it on that ground. And, those suits sometimes do go somewhere. And, our law firm does do that kind of work, both, on both sides of it. And so, yeah, exactly. But I mean, that's the point is that like, you don't have to own it for it still to be a dick move. And, courts tend to see dick moves and they give they give recourse in that way.
There's one thing. Go ahead, Scott.
There's a similar issue that's I think even more interesting. So rather than just removing access to content, think about like nerfs and bans. So if you spend all this money to buy like the best Magic the Gathering card and then it gets banned from competitive play, do you have a cause of action? And I mean, that's been the subject of a lawsuit. Like, I don't think that it went very far, but we're concerned about, hey, they turned off our access to this content, but what if you bought this because it was amazing and they decided, let's not make this amazing anymore? Are you legally owed compensation? I think a lot of times, Blizzard will give out compensation when they break some cards or something, but in Hearthstone, but yeah, I think it raises a lot of the same issues. And again, it's unfortunately the contract kind of rules the day.
Front row, yes.
Do these licenses extend beyond the user? Can I will my Steam library to my son or my iTunes library to my child the same way I give my physical media? Like if I buy a physical copy of a game, I can give it to my son or my daughter or my cousin. But if I have a Steam library, what happens to that when I die?
Can you inherit some of these digital assets licensing-wise?
Yeah, so the answer is it depends on the service. I think... Yeah, the answer is it depends on the service. Netflix accounts I know are supposed to be individual specific. Good luck with that. Godspeed Netflix. Fantasy Award of the Year. No, and I think Steam is technically like you can get into, and so I know some of them, and I'm just riffing here because I have had these conversations in the past and I just do not remember which companies do it which way, but some of them do have processes where if somebody passes away, the next of kin can say, I can't get into their Steam account, like, what do I need to, and there is a process for this.
Yeah, but again, that's not something you're entitled to as a matter of law. It's something they just provide as a service. I think most terms of services would have like default fine print saying that their contracts are non-assignable, which basically just means I can't, as a user, give my agreement to somebody else.
Right.
Yeah, I mean, I think that just highlights why the contract is key in the licensing society, because in that example of the iTunes thing, case where you make a copy of the song and delete your own, that's making a copy. But if it's your computer that has all your games on it, I think in the absence of a term in the contract, then yeah, your next of kin could have that, or you could sell that computer to somebody else. But when we're in a society governed by licensing contracts, it can say this is not transferable, and they're just allowed to do that, and you agreed to that.
Yeah, and they probably are going to have that language also, because if they didn't, you'd have people doing reselling on the black market kind of.
Can we, before we do an audience thing, can we real quick get the soapbox about Microsoft Activision?
Oh yeah, sure.
Merger.
Oh, yeah.
Go for it. Yeah, we kind of seamlessly went into this Q&A, but yeah, let's do it.
Anyway. Yeah, so Microsoft, Activision, Blizzard, I'm assuming, how many of you have heard of this and are vaguely familiar? Okay, so most of you guys. So the very, very short version is that Microsoft, in its Pac-Man tendency to gobble up everything it touches, is now gobbling up Activision, Blizzard, or attempting to. The Department of Justice filed a lawsuit to try to stop this from happening, saying it would be basically an antitrust violation. And before you go like, oh my God, there's a lawsuit, that's just how the DOJ blocks mergers, is via lawsuit. So there's a lot of concerns around this. The one that like Sony has is, oh my God, Call of Duty. Literally, I challenge you, read the complaint. The complaint starts off with, well, Call of Duty is a very important game and it shouldn't be a console exclusive, which is funny to me because we've had console exclusives as long as we've got consoles, so this is not a new problem that you can tie to the merger. The more interesting question for me is this puts Microsoft to a degree of what in antitrust we call vertical integration, meaning the entire pipeline from development tools all the way down to the Xbox Game Pass marketplace is all going to be under one house. And what does that mean for indie developers? It's very easy to imagine a situation where Microsoft, they have Xbox Game Pass. They control the shelf space, basically. When I log into Game Pass, they are the ones who tell me what's up in front of my eyeballs, what I get to see is available. And there is a review process to get on the Xbox store. And there's a very serious possibility that they could leverage their ownership of Azure, which is like I think that's their cloud development platform, and basically say, well, games that are made with Azure, we can review faster. So you can get to market faster. And it's this soft power kind of stuff. Is really just like very concerning. The other thing that I will flag, because again, as I said earlier, I mostly work on the music industry, which is a mess. I was about to use some 4-letter words. I will refrain. There are a lot of problems that come with the unlimited access subscription model. They're great for consumers because they're super cheap. I pay Spotify $9.99 a month, and I get access to more or less the entire catalog of human recorded music that has been made, or the closest thing ever assembled to it. And if anyone's ever followed music news, you will know that this creates a lot of problems for artists, and it's caused a revolution, some good, some not so great, in the music industry. And it's become very unsustainable. And the question we had earlier about, do you own your MP3? Like, what happens if I get locked out of my Spotify account? You don't actually own any of that. So it just kind of poofs along with your account. And so there's a real concern that as we've moved away from physical ownership and to this sort of Netflixization, really, where everything is a curated catalog that they can and will change at any given time, that is the Game Pass model. Like, you have access to whatever they feel like giving you access to for that month. And so there's a lot of concern, especially for smaller independent developers. I will weep no tears for Bungie. If they get dinged by this, whatever. EA, go off and do your thing. I'm more concerned about the little guys who, are trying to make a living out of doing this, or it's their first or second title, and all of a sudden, if they don't play nice enough with Microsoft, they've just gone poof after 2 months. And so there's a lot of ways in which this model reentrenches existing market power for these really big intermediary giants. And we're super concerned about this, and we know Xbox Game Pass is already happening. And so there's a lot of talk in the policies here about how do you correct for this? Do you want to correct for this? Because again, it's a huge, consumers actually are getting a lot of value out of this, but it's all the problems that it's creating in the ecosystem are felt farther down the line and by people other than consumers who often are not organized enough to speak up in these policy debates when they happen.
Yeah, it's really interesting. I mean, along the same lines of, we're still seeing this big, knockdown, drag-out fight between Apple and Epic, over, platform fees. And again, this is another situation where, Apple created a marketplace where it really wasn't one. The apps, they should probably be able to reap some financial, benefit from creating this platform that has created a ton of money and, brought a whole bunch of people into the world of gaming, frankly. But, yeah, is 30% of all, revenue generated on the platform, is that fair? Probably it's a little high, considering that they're not doing that much. And I think, this is one of those areas where I think perception and market forces and the legal part of it kind of intertwine, right? Even if you don't necessarily win on your antitrust lawsuit, you can put a lot of pressure on a company by accusing them of being this unregulated monopoly, and you can get change to happen that way. And Apple is starting to loosen up on those rules, and it's really just interesting because this is all we're lawyers, but we play a small part in a much bigger ecosystem of market forces.
Authentic Sports, fourth row, yeah, you.
Tommy Tallarico and the Roblox scoop, or I guess also similar to it, him advertising his television amigo using the name recognition of folks that are no longer working for his company.
Yeah, so the question was about Roblox.
And Tommy
Tommy
Tallarico.
These are words, and I have heard them, but unfortunately, I don't know what they mean.
I'm also not aware of the situation you're talking about. Unfortunately, I haven't heard of this.
Advertising his new console, which has yet to release, by advertising like, oh yeah, we got the guy that founded Xbox. We got the person who used to be the Mattel product lead. And he was actively advertising as them being on board the project. And one of them has not been on board as of a year prior to his notification.
Okay.
The other one is so not on board anymore that it's not even listed on his LinkedIn.
Okay, so apparently Tommy Tallarico is advertising something saying that certain people are involved when they are no longer involved. That
Seems bad.
It seems bad.
Yeah,
It's really going to come down. It
So
really comes down in a large part to exactly how that's being phrased. If it's, senior VP from Mattel helped us out at one point on this, that's a factual statement. That's correct.
He's been involved and he's making huge changes.
Yeah, that strikes me more as
I think none of us really know the details here, and I think that really it's just if you're committing fraud, that's fraud, and I don't know the details of this case.
Don't do a fraud.
Yeah,
I could see people who backed a Kickstarter being able to come back and be like, actually, this was fraud because I gave you money because you told me this stuff. That's called acting in reliance. There's your law lesson for the day.
Yeah, exactly. Yeah, I think the high-level legal principle is false advertising is a cause of action under consumer protection law. You have to be able to prove that you bought the thing because of that representation, which can sometimes be hard because there are lots of other reasons you might buy the thing. The other part of it that I think you touch on is the rights of the employees to appear in advertising. That again, it comes back to whatever the employment contract says. But people, particularly notable people, have rights in their image and endorsement. It's called a right of publicity. I don't know.
In some states.
Yeah, in some states, I'm again grossly oversimplifying, but people do have a right to object to people saying that they endorsed things that they didn't endorse. And that doesn't have to be an explicit endorsement. It can be an implied endorsement. So all good things to be careful about when you're putting together advertising for your thing.
Can we get someone from the back? All right, questions in the back. You pick one.
There in the end there.
Yes, dark blue shirt.
Yeah, blue shirt, black mask. Stand up.
No, blue shirt.
Blue
No,
shirt.
no.
Here you go. We got you.
Dueling black masks.
Yeah, you standing up.
The person wearing a mask.
Going back to end user license agreements and how they're so lengthy and complex that, generally understood that nobody is reasonably expected to actually include. I was wondering if there was any way to legally change them to make them more palatable to without sacrificing.
Yeah, so
Okay.
the question was how end user license agreements are impenetrable. Is there something we could do to make it better, right?
Yeah.
So I think without a legal requirement of what exactly needs to, there has to be a legal mandate of standardization before anything is going to really change. Because I'll tell you, the Europeans have been trying to do this. They've been trying to make it more palatable, and by doing so, they've added 50 pages. I'm exaggerating a little bit, but it's that old Simpsons quote of I want everything in one bag, and I don't want that bag to be heavy. So. It's really hard. I write them for a living. It's really hard because they have to cover a lot of stuff, and actually they do get read. They don't get read by people who are just playing the game, but they do get read by people who are planning to break your EULA, and they absolutely get read by the people you ban, because once you ban them, they're going to look at, prove that I did something wrong. It's no, you here's the chapter and verse that you violated. So you'd be surprised at how often the language of them does get scrutinized, and it really does have sort of invisible effects on everything else that happens in the game. Because if you don't have that language, then people are going to exploit those loopholes, and it's going to just wreck everything. I'm exaggerating, but that's kind of the point.
Yeah, there really is a trade-off between having that precise, sometimes dense legalese on the one hand, and the readability. And I've done it both ways. Really depending on kind of what the client wants. If you want something a little bit more reader-friendly, maybe kind of silly, that's fine. There is a trade-off, on the other hand, of some of these issues. The law knows exactly what a worldwide, perpetual, fully paid-up license to make derivative works means. You might not know what that means, but the courts do. And if you kind of put that in more human terms, you've suddenly introduced a lot more gray area that people could potentially, bad actors could potentially take advantage of, or you might inadvertently signal to people you're forbidding something you didn't really intend to forbid, or allowing something you didn't intend to allow.
Yeah,
contract drafting.
It's really weighing.
Contract drafting is sort of adversarial. You do it because, like Joe pointed out, most of the time when someone reads it, it's because they're going to fight you. And occasionally you can have fun with it. Like for a while, the iTunes agreement forbade the usage of Apple software in nuclear missiles.
Yeah, something like that.
Somebody dug that up a few years ago.
Actually,
if you read the attendee agreement or the privacy agreement here at MAGFest, if you get all the way to the bottom, they're like, "Did you read this?"
Yeah, I've definitely had clients who have asked me and paid me to write friendly versions of the terms. I'm happy to do it. I love doing it. It makes me very happy to be able to get creative and to try and make these things palatable. Usually I'll do like a 2-column approach where like, here's the plain language for, not dorks, and then here's the dorky language. I will say, as much as I love doing it, people still don't read it, so it's kind of, so it's a little bit hard to justify that expense. But I, as a person, because this is what I do for a living, it's something I put a lot of pride into trying to make that language as clear and, easy to parse as possible. But it's hard.
I mean, even with the plain language explanation, there's usually the disclaimer that the detailed language is what controls. So, but I think it is positive to know that there have been some trends in the direction of trying to make things more approachable, trying to make it digestible, whether that's coming from the app stores trying to say, look, here's what permissions you're really giving in this long agreement, or companies who are just trying to tell people this is what we're doing. We're also seeing just between companies, to the point of contracts are sort of adversarial, because you're advocating for your side and what you want. We are seeing some positive trends towards basically open source contracts where it's a standard language agreement and you just kind of agree what are we going to mess with, and then this standard language that everybody's seen before governs. And it'd be great to see something like that come to things like EULAs and other areas.
Oh yeah, no, there are definitely templates out there. Just a lot of them are bad.
Yeah, if you decide you need to get some kind of contract template, don't pull it off the internet. I will do that at least to start, but I know what I'm looking for, and then I will take and adapt it to whatever purposes I have in mind.
So don't pull it off the internet. Pay a lawyer to pull it off the internet.
Right. But I work with a lot of indie developers, and they don't have the massive legal budgets to get a brand new contract for from scratch for everything. I'm happy to get the template, but I know what I'm doing, and I can at least work with the person. Okay, how much do you feel comfortable adding, changing this part every time, or come back to me and I'll, take 10 minutes to tweak it, and that's not super expensive, or whatever. But yeah, please just don't go stick into Google. Oh, I need a licensing contract. I'll make a lot more money fixing that later than if you just pay me to do it the first time right.
I think we got time for one more.
How much time do we have?
We had,
about 10 minutes.
Oh, do we? Because it says till 2:20 on the schedule, but we can go. No one's gonna. They can fight us.
They can sue us.
This is what we call adverse possession.
Yeah.
All right, Mag staff says only one.
Oh no, we
rights.
just totally cooked the bear.
We'll see how it goes.
Okay, 10 minutes. Okay.
I'm not here.
I know we got a repeat attendee up front. What's up, Ingrid? Yeah.
Yep.
So we talked a lot about ownership of digital content where there is a clear creator. What happens if you now apply to your cloud save file, where if you were to put hundreds of hours of a game and all of a sudden that game goes to a different provider due to exclusivity of content, do you have to now do that, spend hundreds of hours again? Or will it be something where we have issues for ownership of your cell phone number.
I mean, I think
Portability.
it's the same kind of.
Yeah, so the question, just for folks in the back who may not have heard it, is so how do we handle, how can you think about situations where, say, you've played 100 hours of a video game, the video game is then transferred to a new owner, do they have to honor your old save file and all the progress that you have in it?
So I think I've done a couple of like game merger deals, and one of the logistical challenges of having two big companies who have their own tech stacks merged together is you really got to be careful about not accidentally nuking data like that. I think when it comes to the legality and your recourse if it happens, again, you're back to the same question of, do I own it? Probably not under the ELA. Can I argue that it was, consumer protection? I've been wronged, because I wouldn't have put 100 hours if I knew it was going to get nuked. I actually think that's probably a kind of hard sell too, because is the expectation that your cloud saves are going to stick around forever? Maybe, I don't know. But I think you're again, this is one of those areas where maybe the law doesn't help you, but if enough people get mad, the companies will make sure it doesn't happen again.
Yeah, exactly. This is almost less a legal issue, more a business issue. They want their customers. When they're merging the games or taking it from one platform to another, and it's just bad business to piss off your customers, who are the people who you want to buy your stuff and pay you microtransactions and everything. So, not everything becomes a legal solution, but certainly there are theories that could help you recover.
I think we have time for one more. Let's go over on my left. But yeah, you look behind you with the glasses and the sweater. Yeah.
So kind of going back full circle, you mentioned like AI and music and all the tech that's related with that. A lot of my colleagues are actively researching that kind of stuff, like creative AI, Jefferson, games. So in the little bit of time we have left, I'm just curious kind of what legal quagmires you run into.
So very many. So the question was about AI and music and just sort of generally what are the problems that have been cropping up. Again, that is a thing I could fill an entire soapbox about. The short version is it's a question of ownership. So question is if you've got, and this has actually happened where a couple of developers made a program that would use AI to generate basically beats. They put them out there to be sampled, the idea that people will use them in remixes or what have you. And they registered a whole album of them at the Copyright Office, and they were AI generated, but they put the names of the folks who developed the AI on the ownership application. And this caused a lot of debate. And I think they were given the application, I think it was granted. You get a copyright, there would be a copyright regardless if there was a human being. The application process is purely a formality. It's a registration anyway. But the short version is one of the proposed answers to if a robot makes it, who owns it? One of the proposed answers is the person who made the robot, clearly, which is a real concern because that would imply that Adobe owns everything you've ever made in Photoshop. I don't want to live in that world. I don't think Adobe wants to live in the world where they own my stuff. Just gonna put that out there. It's a legitimate question. And the other one that comes up a lot is, if you have an AI that, nowadays AIs are mostly being trained on very large data sets, or the largest they can get their hands on. The question of specialty AIs. So what happens if you train an AI purely on Beyonce tracks? And then you have it generate something, do you now have a Beyonce? And I got quoted in The Verge for that one, and I'm going to use it till I die.
That's really cool.
Yeah, so what... At that point, what do you do? Is there actually a problem there when you've only trained it exclusively on the works of one artist? We talked earlier, you can't copyright a style, but you can get real close to it sometimes. There was a big, terrible, awful copyright lawsuit where the estate of Marvin Gaye sued Robin Thicke because of the bass line and blurred lines. The decision was basically, we think you can sort of copyright a style. It was real bad.
Yeah, sure, why not?
Yeah, I don't know. We think this is bad. It's a lot of fair use stuff kind of comes down to a sniff test, and the court was like, it smells fishy, and that's not a useful precedent for anybody.
It's also, I mean, in an infringement analysis, so I'm going to get really super nerdy right before we leave. So in an infringement analysis, so we talked about substantial similarity. I'm going to dig into it a tiny bit more. I'm still oversimplifying, so don't, the way that substantial similarity analysis works, you can't copyright the idea of a horse, right? Obviously, but there are certain elements of a depiction of a horse that might be subject to copyright protection in a substantial similarity analysis. So, I have drawn a picture of a horse. You, Meredith says that, oh, you copied my picture of that horse. We then, as a court, have to do a thing called the abstraction filtration comparison test, which is so much fun. I love it. It is incredibly abstract and nerdy, but basically you're supposed to say, okay, so what elements of this picture of a horse were dictated by the fact that it needed to look like a horse? So it's got, fur, it's got, hair? I guess.
4 legs,
yeah, 4
it's got a
legs.
mane.
4 legs and a tail.
So you have to, and then take all of that stuff,
Equine-shaped.
and then you're supposed to filter it out.
Plinko.
And whatever is remaining, that is what you draw the comparison, which is bizarre when you're talking about, a picture of a horse. Okay, well, in my horse, I drew, so a great case is if Meredith's horse had 3 eyes. And then my picture also had 3 eyes. Well, that's not really dictated by it being a picture of a horse. That was a creative, expressive thing that Meredith added, and that's what I copied. And that is incredibly, incredibly useful in the game cloning context. That's exactly what we do. We look at 2 games, game cloning is a huge problem, and we look, okay, so these are both farming games. Okay, a farming game, by the nature of the fact that it's a farming game, it's going to have crops, it's going to have, built mechanics where you're harvesting wheat and barns and whatever. But can we filter all that stuff out and see that there's still stuff that wasn't dictated by functional or sort of savoir-faire, which is another whole thing. Things that...
Just going to go into that.
Yeah, I know. You can go into it.
Yeah, you are.
But is there stuff that was actually the source, creatively sourced, and if you stole that, then you have a much stronger case. It is so interesting and complicated and requires you to really deeply know not only what was creative, but also you need to actually be able to make the thing in order to know what was dictated by function. I love it. It's my favorite thing.
Yeah, so savoir-faire, and I'm just going to interject here. Joe and I were actually interns back in law school together. So we've been fighting about this for over a decade at this point.
Fighting.
Well, we've been having fun disagreeing.
Yeah.
So savoir-faire. So savoir-faire is, first off, it's French, so I'm pronouncing it wrong. But it's this idea in copyright law that there are certain kinds of stock characters and tropes that we just use by virtue of living in a shared storytelling heritage. Humans have told each other stories since man first drew on the walls of a cave. And there are certain things that we just go to over and over and over again. They are stock characters. Fun enough, one of the sort of definitive cases about this was a lawsuit between Seth MacFarlane and Neil Gaiman.
Mm-hmm.
Tom MacFarlane.
Yeah.
I'll see myself out. Yeah, exactly. Yeah, no, it was about Spawn. And it's fun because the judge who decided it had a copy of one of the Spawn comics where somebody was very scantily clad on the front and he was waving it around in the courtroom. But the idea was behind some of the side characters in Spawn, and I don't remember the names of the characters, but there was what's that?
Angela and the medieval Spawn.
Nice.
Yes, it was the medieval Spawn. Yeah, I don't even know why I'm telling this story. You guys know this better than I do.
MAGFest crowds are the best.
It's the best. Yeah, anyway, so the cool thing was basically they're the aged old wise man who has a secret agenda is just a part and parcel of the stories that we tell. Just like having the old crone or the virtuous thief or whatever. And so a lot of the time when we get bogged down in these questions about is someone copying, especially when you're talking about, God help me for what I'm about to utter, the Omegaverse lawsuit. Oh. I got to be on a panel with Lindsay Ellis about this. That was the best day of my life. Yeah, so the Omegaverse lawsuit, for those of you who are not cursed enough to be deep in the fanfic world to know what this is, Omegaverse is a fanfiction trope. So you've got your coffee shop AU, you've got your high school AU, you've got your wolf sex AU. And Omegaverse is based on this fundamental misunderstanding of how wolf packs work, but it's this like particular dynamic of shipping that anyway, it's very complicated. It's got its own internal structure. And there's an entire genre of basically self-published, like, non-fanfic lit that exists mostly on Amazon, which is where most of the self-published authors go. And somebody came out and said, actually, I invented Omegaverse, to which the entire Supernatural fandom circa 2012 went, excuse me? And they brought a lawsuit against another Omegaverse writer who was also writing original Omegaverse fiction, saying, you copied I invented the Omegaverse system where there's an alpha and a beta and omega, and please God, don't make me get any deeper into it than this. And there was a lawsuit about it, and the lawsuit was patently ridiculous, and Lindsay Ellis did an entire gigantic video. It was a two-parter, actually, because after the first part, she got an angry legal threat from the woman who had brought the suit, saying, I'm going to sue you too. Nice. And Lindsay Ellis was like, game on.
Yeah.
I have one of her hats she made afterwards.
Oh my God, it's so good. And we were,
prejudice.
and I am very proud to say, I was accused of being part of the fanfiction deep state by this person. Thank you. It's great. It was us and EFF and the folks who run AO3, and we still call each other that on very important conference calls. But this is a classic sense of air question. This is, as weird and new as it is, this is a series of tropes that exists entirely within its own ecosystem to the point where people who read it already know what it means because it's been that inculcated into them. If you are not one of those people, please, for your own sake, maybe stay that way. But yeah, no, these are the kinds of things that like copyright lawyers have to think about. As like weird as they may be, it's, where do we draw the line between copying versus just reinterpreting something that's sort of in our collective lexicon in a way that ends up coming out similar to somebody else.
And there have been a lot of game cases based on that. Like from the beginning, like karate, two different karate games, they look similar, okay, but we're both doing that centuries-old martial art that has to look that way. You don't get to own that. All the way to...
So it was the Data East one, the Street Fighter clone.
Yeah, there's a Street Fighter clone, and again, that was... part of it was martial art, part of it was, you have a health bar, so do we have a health bar. That's infringement. Like, nah.
Just imagine.
Well, no, but Data East lost because they didn't just copy, Saints Affair. They also had like the guy doing like a hurricane kick and like a sonic boom, and like they had the same motions for the same sorts of fireball things. So they said, okay, well, those aren't dictated by the genre, and.
But there were things like health bars were brought into this. You have a health bar, so do we. That's terrible. Like, and the judge was like, no, it's not. That's how you do it.
Yeah, I think
this is why we need more millennials on the bench.
Copyright analysis can get really challenging, and it can be really inconsistent from case to case. But just one takeaway from the lawyer panel is that if you are concerned about copyright infringement, it's about choices. It's about expression. Why did you do it this way? Did you do it because that's the language of this space? That's how we tell a story about wolves getting together or whatever.
Nasty.
Or is that part of the choices that you made that are expressive and artistic or creative or whatever you want to call it, and sort of finding, did you copy somebody else's arbitrary artistic choice, or did you copy the common elements that we have to have a conversation about martial arts games?
And the upshot of this is if you are a very successful artist, or game designer, you may invent something that then becomes the language. You are so good that then everyone else starts doing it. This is in trademarks, we call it genericide. It's why you call tissues Kleenex. We are being caned off the stage. Yeah. So,
we'll still be around, but thank you. Yep. Thank you guys for your questions. That was fantastic.